What's up, everybody? And welcome to our answer from the judge in Sarah Boone's case on her motion to suppress the entire 2-hour interrogation. In today's video, we're not only going to read the judge's orders, we're also going to watch the clips that he references from the interrogation because it's very clear that he watched this interrogation video. He didn't have to necessarily, but it makes sense for him to. And from my perspective, it clearly played a role in his final decision. So we're going to watch those parts together, react to it, apply what the judge says to it, see if we agree with it. And then also, we're going to read through the judge's order regarding hair and makeup. So let's get to it together. Make sure you guys all hit that like button. Here we go. So I wanted to start with the order, and then when he references part of the video, we will go to the video and watch part of that interrogation, and then we'll go back to the order, and then he references yet another part of the interrogation, which I thought was interesting. And he makes a good point, and it's something that we kind of discussed together as well that happened kind of throughout, that when we look at the totality of the circumstances, I think we can understand how the judge got to his final determination. So first, let's bring up the order. Oh, that's the wrong one. All right. So here's the judge's order on the motion to suppress. Order on defendant's motion to suppress, defendant's statements at OCSO, on defendant's amended motion to suppress, defendant's statements at OCSO, and on defendant's second motion to suppress, defendant's statements at OCSO. This cause came before the court on October 2nd, 2024, on the defendant's motion to suppress defendant's statements and the amended motions to follow. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion and the second amended motion, having reviewed the court file, having considered the testimony and evidence offered by the parties, having considered the arguments offered by counsel for the state, having considered arguments offered by counsel to the defendant, finds as follows. Defendant Sarah Boone is charged by way of information. Filed on 3/23/20 with a single count of second-degree murder. On February 24th, 2020, defendant called 911 after finding her boyfriend, George Torres, deceased. Deputy Kayla Rodriguez arrived on February 24th, 2020, and spoke to defendant. See also Exhibit 1. Detective Copsell, a homicide detective at the Orange County Sheriff's Office with 6 years of experience as a homicide detective and a law enforcement officer since 2013, was the lead investigator of George Torres' death on February 24th, 2020. Detective Copsell arrived at the scene within 30 minutes to an hour of OCSO deputies arriving, was briefed, and performed a walkthrough of the apartment. Thereafter, a search warrant was drafted. Detective Copsell then made contact with the defendant outside the apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. The defendant's cell phone was collected after CSI documented the scene. Detective Copsell wanted to go through the defendant's cell phone to corroborate the defendant's story. You notice how he put in there to corroborate the defendant's story. Defendant signed a consent prior to the February 24th, 2020 interviews as addressed below. See also defendant's Exhibit 1. Detective Copsell did not look at defendant's cell phone, including any videos, prior to the interviews addressed below, as digital forensics did not arrive until approximately 7 p.m. Detective Copsell then made contact with defendant's ex-husband, Brian Boone. Thereafter, Detective Copsell and Lowen had an interview with defendant in Detective Copsell's unmarked Nissan Pathfinder at approximately 5 p.m. See also states Exhibit 1. Detective Copsell explained that she wanted to have a conversation with the defendant after walking the apartment. Detective Copsell testified that she would not have interviewed the defendant outside the unmarked vehicle, had no memory of using the words routine, and that everything was explained on the recording. The word routine is not used by Detective Copsell in any recording, aka this judge has watched the recordings. Detective Copsel. Oh, hold on a second. Oh, shoot. Dang it. All right. Sorry. It's just one of those days. I have moderators, but you guys realize that when I'm reading a document, I'm also not looking at the screen. Sorry about that. Is this the right one though? No. Gosh, I keep clicking the wrong one. All right. Well, that sucks. So sorry everybody that was watching, but to everybody that's just listening, I've just been reading through the court's order. No big deal. I don't know how we can fix this maybe for rewatch, John, but that sucks. Oh well. Where was I? We were reading about Detective Copsel testified she. Okay, then word routine was never used in any recording. Copsel explained the purpose of this interview, including defendant's prior conversation with Deputy Kayla Rodriguez and Detective Copsel, and Detective Copsel's desire to get a further understanding of what happened last night and ask the defendant more detailed questions. Thereafter, Detective Copsel began reading Miranda as follows. Detective Copsel said, I am going to read you your rights, but it's just because that's how we do things. So you have to do, so you do have the right to remain silent, okay? Do you understand that? And the defendant said, yes. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before question without charge. Has anyone threatened you or promised you anything to get you to talk to me? Boone said, no. Detective Copsel, do you understand what I just read to you? Defendant, yes. Thereafter, Detective Copsel interviewed the defendant again after the initial digital recorder's memory was full. A second separate recording was initiated. Detective Copsel confirmed with the defendant that no additional communications occurred prior to the second and separate recording, and Detective Copsel inquired of the defendant prior to asking any questions, you do understand that you don't have to speak with me if you don't want to, correct? To which the defendant responded, yes. After concluding the interviews, but before leaving, Detective Copsel had conversations with the defendant, had about coming to OCSO the next day to address the pending autopsy, and that Detective Copsel would have more questions. So this happened all before, and that's important. All of this is important only to the totality of the circumstances, because this is not the interview that the defense was challenging. This is not the interview that the defense was trying to suppress, because this interview, everybody kind of agrees, was fine. And I think the reason the defendant focused more on the second, or the defense focused more on the second interview than the first, is number one, the second interview had all the damning information. That's the first issue. But also the second interview, they're saying, was used deception to talk to her. There's no argument that there was no deception here, but according to the recordings reviewed by the judge, Copsel said, we're going to talk tomorrow about the autopsy. And multiple times said stuff like, you understand, you don't have to talk to me, correct? Which from my perspective, shows how consensual this was. How this was not coerced. How this was not forced. And that's why I think the judge uses this to set the stage, even though this is not the interview in question. This is not the interview that they're trying to suppress. Somebody said, love the Miami Vice shirts. Thank you. It's so annoying that I just spent the first 10 minutes reading the wrong document. I got to just not think about that while we go through the rest of the video. Okay. After concluding the interviews, but before leaving, she told her we're going to talk the next day. Detective Copsel did not recall speaking to the defendant about their cell phone, but had the defendant asked about getting the cell phone back, Detective Copsel would not have given a specific time frame for returning the defendant's cell phone. Detective Copsel had no memory of receiving a call from the defendant on the evening of February 24, 2020. Defendant's testimony largely agreed with Detective Copsel's testimony, including the timeline of calling 911, speaking to Rodriguez, speaking with Copsel. As to the February 24th interview, the defendant confirmed that Detective Copsel explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. The defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. However, there was nothing evidencing defendant being intoxicated or under the influence of alcohol when clearly speaking and interacting with Deputy Rodriguez. The defendant's statement of making a phone call to Detective Copsall between 9:30 and 10 p.m. on February 24, 2020 from her ex-husband's phone does not line up with the defendant's own timeline of staying at the scene for 10 plus hours, which began at 1 p.m. The court finds this statement lacks credibility. So here's an issue. Copsall says there was no call. Defendant says there was a call. Defendant says in that call there was deception. She said you can come pick up your cell phone. Copsall says I never said that. So the judge has to determine what's credible, what's the appropriate timeline of events. And so the judge says, I find that the defendant's statement about the phone call is not credible. One, because Copsall said it didn't happen. But two, and maybe more importantly, and it doesn't look like he's just believing whatever the cop says, right? Because that's not how it's supposed to be. But he's saying Sarah Boone's own statement does not line up with what she said. She said she was at the scene for 10 plus hours, started at 1 p.m., would be 11 p.m. So how could she have called Detective Copsall at 9:30 or 10? Now, assuming arguendo that Sarah Boone was estimating, the difference between 9:30 and 11 is not really that much, especially when you've had this chaotic of a day. But if you're trying to determine credibility, it's fair game to use that, and that's what the judge did. The defendant claimed that before they left the scene, Detective Copsall or Lowen would return defendant's cell phone to the apartment. On February 25th, the defendant, it says 2024, I think it means 2020. Defendant claims that defendant and Detective Copsall had a discussion regarding the picking up of the defendant's cell phone, specifically that due to Copsall's pregnancy, defendant needed to come down to OCSO to pick up the cell phone. Defendant's sole reason for traveling to OCSO was to pick up the cell phone. The court finds the defendant's statements regarding picking up the cell phone also lacks credibility. All right, I actually want to pause here for a second. So we've talked a little bit about, I can't pause yet. Can't pause yet. But there's a couple clips that are very important from the interview we're going to listen to. On February 25th, after Detective Copsall reviewed some of the extraction of the defendant's cell phone by digital forensics and attended the autopsy, Detective Copsall requested the defendant to come to OCSO's office. Detective Copsall did not want to approach the defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez. The state and the defense agree that the February 25th, 2020 interview was custodial. The pith of the defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective Copsall says, just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Detective Copsall, appreciate you coming in. Defendant, yes, ma'am. I want to ask about these when we have a moment, referring to her pre-prepared written questions. That's going to be important. Detective Copsall, sure. So obviously he received his autopsy. So I'm going to read you your rights again, because we have to talk about that. I'm going to read you your rights first, then we have to talk about that. The judge said that timing is important. And since I'm talking about the incident, we just have to do it. We just have to do it, Owen said. Coercive, forcing, just like we did yesterday. That's also why it's going to be important to watch this video. And I always thought it was interesting Owens quoted it instead of just citing the link. Defendant, normal protocol, which she said she didn't remember saying, I think. Detective Copsall, just like we did yesterday. Remember, I read your rights. Defendant, yeah. Detective Copsall, yeah, it's exact same. But since I'm asking you follow-up questions, I need to read them to you, okay? Sure. All right. So you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during questioning without charge. If you can't afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? No, Detective Copsall. And do you understand what I just read to you? The defendant, yes. Okay. So now that we know kind of the background and the facts as explained by the judge, the footnotes are interesting as well. So we're going to read them. But first, I want to take us over for a question or for a second to watch part of the video. And this is kind of what all this has been about. And let's remember, and we're going to get another lesson here from the judge. We're going to talk about Miranda. We've talked about Miranda a lot. So from my perspective, the totality of the circumstance argument as to was this coercive, was her rights violated, was this a problem? That is why I wanted to watch again the beginning of this interview. We are going to listen to about 10 or 12 minutes of it, okay? The really important part about Miranda happens in the first minute or two. But then I want to listen to the first 10 or 12 minutes so you can get a feel and a vibe of if this feels coerced, if this feels forced, just through the first 10 or 12 minutes, which you know the judge is watching this thinking the same thing. Also, this first 10 or 12 minutes will also give you an idea as to why Sarah Boone, just a little snippet as to why Sarah Boone wants to suppress this. All right, here we go.
We sit in the green chair that doesn't move.
And what you hear is going to sound familiar because the judge just quoted it.
Appreciate you coming in.
Yes, ma'am. And I want to ask you about the incident room. We have a moment.
Sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday.
Protocol?
Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
So you tell me, does that sound like we have to talk about it? No matter what, we have to. And we have to do this. So I kind of felt like the defense was arguing we have to do this was we have to talk and we have to answer these questions. But when you listen back to this part again, she's saying we have to read you your rights, right? When she says we have to do this, we have to read you your rights. We have to talk about the autopsy, which means if we're going to talk about the autopsy, we have to read you your rights first. Not that you have to do anything is not the vibe, at least that I'm picking up from Sarah Boone and this lawyer in this discussion. Nothing about the lawyer's tone to me seems coercive. And that's not to say that she's a perfect cop. That doesn't say that they did everything perfect through this interview. But when I look at this, I think there is no doubt in my mind that this cop knew Sarah Boone wanted to talk, wanted to explain herself. I'll tell you from my perspective as a lawyer, seeing a lot of these, being involved in some, watching cops do this, talk to a lot of cops about how this works. When they know somebody wants to spill their guts or somebody thinks they're going to outsmart them and is going to give them enough rope for them to use it, right? That's exactly what I think happened here. I think these cops knew exactly what Sarah Boone's MO was and exactly what she was planning to do. And I think that's what they were going to let her do. Now, sometimes do they overstep? Absolutely. Sometimes do cops do things wrong? Absolutely. Pebble said, Peter, at this time, did Sarah Boone have the right to walk away? No. They said at this point, if she would have said, no, I don't want to talk to you, I want to leave, they would have said, too bad, you're arrested and going to jail. In the squad car, she could have walked away, they said. All right. So let's keep listening. I'm going to back it up again just so you guys can hear the we have to part that I think is we have to read you your rights. And then we'll listen to a little bit of their back and forth.
He received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday.
Protocol?
Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
All right. So you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect. Okay. So this morning we went to his autopsy.
And just for this interaction, I'm going to kick it up just to 1.25 speed so we can get through it, just so we can listen to about 10 minutes of it again, get the vibe. Does this feel coerced to you? Does this seem coerced to you? Ezekiel said, not pro Boone, but Owen's job is to try. He's not bad for doing so. Absolutely not. I said it at length yesterday. I think this is a good motion to file. He made a good argument. He did the best with what he had. I think he's going to lose. He did lose. Criminal defense lawyers lose all the time. They lose arguments all the time. That doesn't make them bad lawyers. Doesn't make them bad people. I have nothing against Owens at all for trying this and filing this motion.
We were informed of some injuries that he has by the doctor. So so he's got scratch marks to his back.
I know what that's from.
Okay. And it's called a contusion. Do you know what a contusion is? So like basically you're getting hit and then, you get a mark from it. You'll get bruising. Like someone hit you or something like that. It's called a contusion. So he had some injuries to his left shoulder.
AKA a bruise, but I just thought that was kind of funny.
He had a cut near his lip. We could see his mouth was a little.
I haven't laid a
swollen.
hand on him.
Okay.
Also too, he fell off my son's bike,
Okay.
so I don't know. And he's notorious for running into the wall or the hall tree. So why?
Okay.
So first off, if this were different and Miranda wasn't read properly and there were all sorts of issues, and if this was just this short little clip that we're going to watch parts of, the cop hasn't even asked a question, right? The cop hasn't even asked a question and she's answering and she's talking. She's just like, there's a bruise on his back. There are scratches. Do you know what a contusion is? A contusion, if somebody gets hit, you can get a contusion from falling, not just getting hit, but whatever. And she's just spilling her guts. All of that is important, right? Are they pulling it out of her, or is she offering the information?
What about the scratches? Because there's also sex.
Yes.
Okay. Because there's also like a scratch on the back of his neck, kind of going, but it's going straight across.
I have no idea what that's from.
And they're all recent. They occurred recently. It wasn't something that occurred post or that occurred a week ago or 2 days ago, 3 days ago. They definitely occurred, the night leading up to when he was.
In all honesty, we have not gotten into it.
Okay.
That's why, the only thing I thought you guys were going to ask me about, which I was going to be honest with you anyway, are the scratch marks on his back.
Mm-hmm.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over the house too, so.
Well, your son was there when? When was he last there?
Oh, gosh.
From my understanding, he was there last Tuesday?
I don't know if it was Tuesday, but yes, he was there last week, so.
Well, we're talking about Sunday. Yeah. We're just talking about what occurred Sunday. Because like I said, the injuries they occurred within that time period.
So you're talking about day before yesterday?
Sunday leading into Monday. You called us yesterday at 1, but the incident, you guys were painting and stuff the night prior.
Correct.
So we're talking about Sunday and then into Monday.
I'm thoroughly confused because we had.
Interesting with the calls. She said you called us yesterday at 1. She didn't say you called me again last night at 10 or 9:30 or anything like that. Sarah doesn't mention it either. There's no mention of that call. Thought that was interesting too.
A good time sitting on the back porch, having wine and smoking a couple of cigarettes, and then decided to go inside and literally paint, do puzzles, and play and listen to music. That's why nobody got out of sorts. This is what's mind-blowing to me. I have no clue. Nobody laid a hand on anybody.
He also had, on the left side of his forehead, he had basically bruising, and on his head and his skull.
I have no idea.
As if something hit him.
I
considered
not
force
touched him.
trauma.
I have not touched him. I have not touched him.
How would you get those injuries?
Tell me and we'll both know. I have not touched him.
Yesterday, when we took photographs of your overall body, and they did the buccal swabs, did they go under your fingernails?
No.
Okay. Are you willing to let us
Absolutely
swab underneath your fingernails?
go for it?
Okay.
This is the type, this stuff is important, right? And I see this question here. She said she understands it, but she did not give up any of her rights. Everything she has done and said throughout the entirety of the process since the cop showed up was her giving up her rights. Absolutely. Here. Trying to prove her innocence. Go ahead, scrape under my fingernails. Take my phone. Here's my password. I'll sign the consent form. Yes, nobody's promised me anything. Yes, I understand my rights. I have questions for you. You don't even have to ask me questions. I'm going to talk. The totality of these circumstances is really important when it comes to coercion and forced. And that's the bigger question, because the case law, we're going to see the judge go through and analyze the case law. And Michelle, I get it. And you guys know I'm a defense lawyer. So I don't want anybody's rights to be trampled on. I don't want anybody to be forced or coerced to do anything. I do not think that's what happened here with Sarah Boone under the totality of the circumstances. And I think this first 10 minutes and kind of throughout her whole interaction is that this is what she wanted to do. I think every single person, when you hear those rights read to you, should say, stop, give me my lawyer. Lawyer, lawyer, lawyer. And that's it. That's what I think people should do. But I don't make decisions for every adult in America or kid. I don't make decisions for people. So when people make their own decisions, they have to live with those decisions. And Sarah Boone, in my opinion, and thank God we have the video, because again, we can learn so much just watching it. We don't have to take anybody's word for it. She made a knowing and intelligent decision. Intelligent doesn't mean it was a smart decision, by the way. It just means that you have all the information and you were able to do it. And she made a decision to talk to the cops that day. That's my opinion. Austin said, as a defense attorney, how do you balance zealous defense while still remaining candid with the court? It's from my perspective, I'll tell you, it's not that hard. Like, we take a PR class, we take a professional responsibility and ethics class in law school. And the questions are like, your client asks you to lie for her. What do you do? And the answers are like, lie or don't lie. I don't lie. I won't. I'm not going to hide something from the court. I'm not going to get rid of a record to try to win. I'm not going to edit a document or picture to try to win. I'm not going to do it. I'd rather lose. And clients that come to me, they know that. And I tell them that. And if they want to walk away, they can walk away. We can part ways. Some clients did it. Some clients are cooked. Some clients you got to make deals for. Some clients have a lot of evidence against them. Maybe they did do it. Maybe they didn't. And there's no deals to be had. So you make sure the state can prove it. That's how our justice system is set up. So I can still remain candid with the court and say, cop, you didn't do a very good job investigating this, did you? You didn't do this. You didn't do that. You didn't do this. Talking about Melendez, you didn't dust their fingerprints for GSR, their fingers for hands for GSR, did you? You can still ask those questions. Can't lie, can't put on a witness to lie. But motions like this are easy. It's like, this is a gray area. This is a decision the judge had to make. I thought it was an uphill battle from the jump, but he's still being candid with the court. And I think he still absolutely has an argument that technically and literally with her words, she did not say, yes, I agree and waive my rights. And technically and literally, there's a card that has words on it and the cop didn't read those cards. And I still think that that's a good argument to make in front of the jury. Copsel, you had an old card, didn't you? The new card says this and you didn't say that, did you? So she didn't, with her own words, say, I waive my rights. And you still decided to ask her all these questions while she was still intoxicated from the night before. You can make that argument to the jury. All right, well, listen, there's a couple more minutes.
I have no idea, and I don't want to seem out of sorts, but I have no idea. We had a good day. Mm-hmm. It was a good day. We've had good days lately, even considering everything that's going on with our jobs and life in general and ex-wives and everything. It's been good. Like, I don't even...
That's not great for a battered spouse defense, right? You can understand why she wanted to get this thrown out.
even know where this is coming from.
Yeah, I think the last physical was probably, you said, I think, what, a month ago? Where you got the injury, right? You said that was
I'll say
a
a few weeks, give or take, yeah.
A few weeks. That was the last, like, physical altercation between the two of you? You said a month ago he hit you with a curtain rod.
Yeah, with a curtain rod. That's why I can't believe you guys didn't take that either.
Wow.
Like, we've been good. I don't know if, like, it's since the last time he got out of jail, like, we've been good, and he's been having his classes and seeing his probation officer, who's amazing. So.
What do you mean by good? What's your definition of good?
The probation officer?
No, you said you guys have been good. What's your definition?
I've been good. I don't think you all understand. He comes at me all the time. He comes at me. So it's either I flee or try to go upstairs and go to sleep. That's usually what it is.
So even within this interrogation, she goes back and forth from everything was good, we were great. Then I flee, he comes at me all the time. So we're going to hear a little bit about maybe the defense. And that's what a good lawyer has to do, right? You got to deal with the bad. And if Sarah Boone says that stuff's not true and you talk to her and you believe her and you don't believe this, or you think she was just trying to talk her way out of it and she was lying to them, but she's telling the truth now. But there is some also discussion right off the jump in the first 10 minutes of this interview where she does say, he comes at me, he attacks me, and maybe some evidence of battered spouse. And why you can hear this little tidbit as to why they think Brian Boone is going to be a good witness for them. We did an entire video on why he might be a bad witness for the defense, but there's a little snippet in here as to what good Brian Boone might testify to.
I don't know if you talked to Brian about any of that, but most of the time when I flee, I go over there. So,
Right, but
You
you're
may have
saying that you
missed
guys
it
have been
'cause
good.
You may have missed it because I paused it right when it was happening. She said, when I flee, most of the time I go over to Brian's house. So maybe Brian's going to testify that she flees to his house all the time when George is being abusive or dangerous, things like that. My follow-up question then would be, if I was the prosecutor, why didn't you go to his house that day? Why'd you lock him in a suitcase and leave him there and then go to sleep? You could have put him in the suitcase and gone Brian. But you didn't do that.
Good. And when I asked you yesterday, the last incident that you could remember was the curtain rod incident, which you said was a month ago. So,
give or take,
right. So what do you mean by he comes after you? Like,
he gets belligerently drunk.
mhm,
Like, I don't know if y'all have looked through my phone yet and seen any of the pictures and the videos that I have taken.
mhm.
And at one point, I started documenting everything.
Okay.
So you all will see in my pictures, bloody fingers, split foreheads, he split my nose. I've got this.
Right.
I don't know if Brian told you about it, where I had to have I had one really bad surgery, but then it got really, 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 really bad, where I had to go like 4 or 5 more times afterwards and then tend to it. From him poking me in the back of the leg.
Right.
So it's,
Then why are you still with him?
everybody asks me that. When I tell you guys this, I really love him. Like I do. And I feel like I can help him. Like I feel like I could help him, which I did, because he came a really long way from where he was in Philadelphia to moving back to here and to dealing with everything else that he's been dealing with.
Mhm.
I've really helped him. I bailed him out of jail, 3 times. I've gone to every single hearing and every single arraignment, everything that I did for him. Gone to see all his public defenders, go to the state. I've gone to the state. I did everything for him because I'm trying to help him, because I had hope in him. And he was trying. He was really trying. And then he starts to think about things, and I think he gets overwhelmed. And then it's like, the next thing I know, he's drinking. So it's like, oh man, I know where this is going to go. So I'm going to go upstairs and read a book, or I'm going to go for a bike ride, or I'm going to do something else. Where I don't want to drink. I don't want to drink. The occasional wine, whatever, or if it's a weekend, that's when you.
So we're only going to listen about 2 or 3 more minutes of this, but Joanne asked, do you feel like Sarah saying normal protocol was Sarah starting to set up an argument for later? Absolutely not. You want to know why I think she said normal protocol? The same reason why she started out talking about how things were so great. That didn't seem to work. So then she started talking about how bad George was. I think she was trying literally everything she could to buddy up with these cops, or talk about how smart she is or how bad George is. Kind of exactly what the last comment said, maybe to try to go against that a little bit. Whatever she could do to finagle the way or manipulate her way out of this, I think that's what she was trying to do. And she was like, oh yeah, normal protocol. I totally get it. I totally get it. And she also says at some point, I know what it's like. I've done the court thing. I've done the lawyer thing. It's like, again, does that seem like with the totality of the circumstances that she was coerced into this conversation? Ann said, how could she claim battered spouse when she is clearly stating we were playing games and having fun? Well, Ann, you've got a problem, Ann. Your problem is you think what Sarah's saying here is the truth. But it seems like Sarah's going to take the stand and say, no, none of that was actually true. I was drunk. He was abusing me. And I did this in self-defense. And it was a scary night. I was in fear for my life. She's got to say she was in fear for her life for serious bodily harm, for battered spouse. So silly you, Ann, and silly me for maybe thinking they were going to go with what Sarah Boone had already stated.
You have a good time. You don't have to wake up the next day. I have to wake up the next day and do things. I have to tend to Lucas. I have to take him to school. I have all this stuff to do. He doesn't know how to, I guess, maintain himself, where I can do 50 things at once and still know the 50 things more prior that I need to get done. He can't process like that. He didn't process like that. So he would literally, not literally, but have smoke coming out of his ears. So the next thing you know, he doesn't want to deal with it. I'm going to go get something to drink. So the majority of the time I would hang out outside or do something else because I don't want to drink. And every time, his job broke his heart. And it made me sad because he had so much pride in his job. And the store that he took care of so much totally went downhill. Mm-hmm. And that broke his heart because he had put so much work and effort into fixing it up. And his manager was awful and basically gave up on all of the employees. So I think that had a huge bearing on why he would drink so much. His ex-wife is bonkers. Mm-hmm. She was all over him all the time. Send me money, send me money, send me money. How can I send you money when I don't have a job? And he's still trying to take care of me and Lucas by paying a bill here or there, getting some groceries. So he always had something on his mind, which is why, again, I got the puzzles and the paint to try to get him off of it so we don't have a drink, or he doesn't have a drink. So when you all see my phone, you can see all of the damage he has done to me and the videos of him smashing my television because he's belligerently drunk. Where most of the time, I just don't want to be there. And I try to help him. I try to calm him down. Eventually, he just passes out.
Well, yesterday it made it sound like you guys were just drinking like a glass or two. Like, yeah, you obviously had the bottle, but you told me on recording, like, that you were not drunk, he was not drunk, you guys were having a good time.
I can't get drunk. Number one, I do not want to get drunk.
She can't.
I don't like being non-complimentous, having my wits about myself. I don't like feeling out of control.
Mm-hmm.
So
I'm just saying, you're making it sound like he's a raging alcoholic today, and yesterday I was kind of asking you those questions, and you're like a little defensive, like, no, we're not alcoholics.
I'm not.
We are not, you know. But you guys were both sober on Sunday, to your knowledge, because when I said you went and passed out, you were like, no, I didn't pass out, I just fell asleep. So now it's kind of like, what is it? Were you guys drinking and it got out of hand and it got physical?
No.
Or is it?
Sunday was one of the better days that we have had in quite some time. He's dancing with my dog. You can see that too on the pictures, him loving the dog. He loves.
So real quick, I honestly think in my opening statement, if I was the prosecutor, I may play this. I may do it, explain how she did it, you know, whatever it may be. And then when I say they're going to put on a defense of battered spouse syndrome, and our response to that is going to be something like this, and just play this.
What is it? Were you guys drinking and it got out of hand and it got physical?
No.
Or is it?
Sunday was one of the better days that we have had in quite some time. He's dancing with my dog. You can see that too on the pictures, him loving the dog. He loves the dog and dancing around, having a good time, and just being happy kind of thing. He doesn't know. I can get like maybe 2-3 glasses of wine and I'll be fine. But I have to have my wits about myself because I don't know what to expect.
Well, let's talk about Sunday. What was Sunday? How were you? Like, how many glasses of wine did you have? How many glasses of wine did he have? The bottle was gone. I mean, I don't know if you poured any out. Yes.
No, that was from previous.
You said that there was a half bottle left
Yeah,
over.
not as much.
Mm-hmm. And then that you had wine. Well, I don't even know how the wine. How'd you guys get the wine for Sunday?
I'm guessing he went to Publix.
Did he do the?
So you get the point. No, everything was fine. That wine was from before. We didn't even drink that much. I can't drink. I don't want to drink. Kelly DD said, Peter, if we didn't know all of the things we know about Sarah, do you think she should have been asked to confirm that she was waiving her rights, i.e. question 9? Kelly, I'm glad you asked this question. And emphatically and as clearly as I can say it into the camera and into the microphone, yes, absolutely she should have been asked that question. I wish every cop would ask that question. The more, the merrier. Make sure these criminal defendants know what's going on and that they're making this waiver appropriately. Even tell them, you probably should get a lawyer. I wish cops would say that. You probably should get a lawyer, ma'am. I wish they would say that. But what I wish they would say, what I want them to do, what I think is fair, is not always the same as how the case law is written. And from the moment this motion was filed, which, you know, most of the time this stuff takes months to litigate, but here it's days or weeks. That's just not what the case law says right now. There are 4 major things that must be read and given in Miranda, and I think they were done in this case. Michelle said, you are right. We are looking at this with all of our knowledge. If we look at just the statement, she did not agree to release her rights, just my non-professional thoughts. I think it's a great point, Michelle, and I think that's sometimes a lot of times where criminal defense attorneys start. It's like, this is wrong. They did this wrong, so let's go to work. But the totality of the circumstances sometimes doesn't go your way. Mary said, didn't the neighbors say she was always drunk? I don't remember. I know that Brian Boone basically said that. Joanne, is there still a plea deal on the table? I have no idea. My guess is there's always plea deals on the table, but I don't know if there still is currently or if it's the same one that was on the table before. All right. Let's jump back for a second to the document. And I'm probably going to pull the wrong document up. Yes, I am. And I did. It's because the one that's showing up at the top of my screen is the one I always click first, and that's the second document I want to read. Okay, so I want to do a couple things here. I want to look at the footnotes. Number one, all 8 questions on Detective Copsel's Miranda card were read as Detective Copsel's Miranda card did not have question 9 because she had an old card. So he's not, the reason he's citing that is she didn't do something on purpose. She wasn't like, oh, I'm not going to ask this last question because I really want to screw with Sarah Boone. I believe with all my heart, soul, and mind, and you know I don't always believe cops, but I believe if question 9 was there, she absolutely would have read it. She had Sarah Boone right where she wanted her. Footnote 2. So was she drunk? Did she not know what was going on? Was her intelligence level lower? Was there a problem there? During the second separate recording, defendant used higher tier words, including compos mentis, which is basically like you're of your right mind. So Sarah Boone's big words literally coming back to bite her. Then this footnote. Approximately 1 hour and 27 minutes into the February 25th, 2020 interview, defendant returns to her list of prepared written questions and specifically asks, am I getting my phone back? See States Exhibit 1. This prepared written question would not be asked if one was told to come pick up a cell phone. So I don't know. He might have watched a little bit of a different video than I did, but I'm going to pull up. We're going to watch about 10 minutes of this here, starting with 118, because what I found interesting about this as well, that again, we're thinking about a judge who has watched this full interview. And if I'm the judge and I'm watching this interview and I see her pull this notebook out, there is so much more on this notebook than, am I getting my cell phone back? So what does that tell me as a judge, if I'm a judge, which I'll never be? It tells me she wanted to talk to the cops. She wanted to ask questions. She wanted, I'll go a step further, to make statements. She wanted to tell them things. She wanted them to know certain things because she thought it would help her. So again, when we're looking at the totality of circumstances, and we're about to read the judge's analysis on Miranda and on the coercive nature of this interview, if we look at the totality of the circumstances. So let's take a listen here.
What does that have to do with you using the restroom?
They didn't want to be involved.
Should I use yours? You gotta use yours.
No, I was asking last night, because, we had several different people in the
Assuming
neighborhood
that
come up
Eli
saying
and
she was
Kim.
drunk on a regular basis.
Eli and Kim. Okay. Did you ask Vinny next door?
Those are the ones next door that she asked to use the restroom, and they said no.
No, she said no.
Okay.
And like I said, she's not a nice person.
They're coming. What are your questions?
Yep.
I can help you with.
Who's coming?
To do the
Yeah,
fingernails.
you said that we could.
And you don't have to allow us to do it, just so you know. So
I left that part in there for that. So he's like, who's coming to do the fingernails? You said you would. The male cop was like, hey, you said you would. Female cop's like, just so you know, you don't have to do that. You don't have to do it. Because she knows Sarah Boone had her hands out ready to immediately let them check under her fingernails. There's no doubt in my mind this cop was not trying to coerce Sarah Boone to talk. She knew Sarah Boone wanted to talk. Nobody said, would it have helped if she said, I was so drunk, I had no idea what was going on? You mean like in the interview? Maybe, because they maybe wouldn't have asked her questions or would have realized there was issues with that interview. But on the stand, the cop has the video. I mean, the judge has the video to watch. So that's tough. Monica said, yeah, but at the same time, battered wives go back and forth. My poor sister-in-law never wanted to call the cops, even with black and blue, like an addiction. I 100% agree with you, Monica. And I don't mean to downplay that at all. And I wouldn't downplay it. But we have context here that this is a day later that you were so in fear for your life that you took the life of your partner. And this is how she's talking about it. That context is important when it comes to credibility. She didn't claim battered spouse at the time. She's claiming it now. So we have to compare the differences in the statements, the biases now that exist that the state talks about that didn't exist then, and figure out what we think is more credible.
your questions.
Yep.
I can help you with.
Who's coming?
To do the
Yeah,
fingernails.
you said that we could.
And you don't have to allow us to do it, just so you know. So don't think that it's
I don't have a problem.
Okay. Just make sure.
So, am I getting my phone back?
Not today.
What about Lucas's laptop?
No.
Not today.
What does that mean?
We're still going through everything.
Oh, that's fine.
You're the one just telling us that
She's like, can I get my laptop and my phone back? And they're like, not today. She's like, what does that mean? They're like, we're still going through it. She's like, oh, okay. I thought you were going to say I was getting arrested. That's what I thought she was going to say.
there's videos that we need to see on it, so we need
That's
to do our
fine.
due diligence that we go through everything.
See, and that backfires on me now too, because now you all think that I had even more, in quotes, intent to do what I did to him, which was not intentional.
What's that?
She's like, you guys keep thinking I had intent. It was not intentional. So she wants to make sure she says these things. That's part of her narrative. And she has questions written down about, or things that she wants to ask questions about that she brought.
And is that correct?
She's asking about your tag in your hand.
No, but I'm asking if that's correct.
No, I'm not going
I'm
to
not
agree to
making
anything that you're saying. I'm not, that you're,
So Robin says DNA under her nails means nothing. They're a couple. 100% agree with you. It's not the point. The point is, if you're looking at the totality of the circumstances, she was willing to waive all of her rights, every right for everything. Do whatever you need to do. I am innocent. I will prove it to you with my words and my actions and my possessions. So if you're the judge, that matters in the totality of the circumstances.
So his probation officer,
mhm.
do you all inform her or do I need to call her?
We don't have to inform her, so if you would like to call her, you can. Are you saying because he's still on probation?
No, but because of the nice lady that she is and all that she's done for him, I didn't know how it was.
Legally, we just have to tell his parents, and we don't go telling,
Everybody else?
I didn't even know who his probation officer was, so no, I wouldn't go tell
So
him.
the same thing for classes. I need to do that too.
Classes. You need to do what?
Substance abuse class and his battery
Counseling?
intervention.
Yeah, we
Something
don't
else I
have
was
to
just
call
curious to
him.
ask. So, other than this, so initially, what was the cause of death?
She is still pending because she wants to hold the body for an additional day to see if more of those bruises turn into something bigger. And she's doing some other tests that she's got to do. So she's pending it for now.
So, and that couldn't have been because of him being in a suitcase? Or
That's
y'all
what
are saying
she-
that I
that's what-
physically did it?
That's what she's determining.
So,
The ones on the head, I asked her, could that have been from the suitcase, and she said she didn't think so.
I didn't touch him, nor did he touch me.
She's asking them about the autopsy and what they found. They're answering questions like, yeah, she said there's bruise here. And Sarah Boone is offering information. Now, they've already done an interrogation. This is definitely custodial. This is just, again, I'm repeating myself, but the totality of the circumstances, she went there with an agenda, with things written down, with things held. She wanted to ask questions, make statements to try and help her case. Daddy's Girl said, I appreciate your take on this bizarre case. Hugs. Thank you, Daddy's Girl.
I'm leaving it at that. So I don't know if you all know how to do this because so that's what I was going to ask you. So are you all updating his parents today or when he gets final, whatever?
What does it matter what we tell his parents? What do you mean?
Because
We're gonna talk with them.
Yeah.
okay,
I have to
but it's going to
like-
come down to me.
What do you mean?
Like, so it's being put on me.
Who said that?
But I'm not, so what is it you would tell them?
We're gonna give them an update, just like we gave you an update on their autopsy.
Okay, so it's whatever
Well,
bruise and
here's the thing.
whatever on the head.
We had to deliver news to them last night that their son was dead. There's not a whole lot of conversation that goes on after that. It's not a very easy thing
Was
to
it
do.
yesterday or Sunday? Sunday. Today's Tuesday, right?
Did we not meet you yesterday? We met you yesterday.
Yeah.
I'm just asking. Right? Did we not meet yesterday?
It's a valid question.
Really? Yes, on Monday.
Okay.
Got it.
Perfect.
So I don't know if I asked you guys or how I find this out other than talking to his parents, which is not gonna happen.
Yeah, probably a terrible idea.
How do you guys suggest?
I forgot about kind of the snark going back and forth between these two ladies.
That's me finding out about funeral.
Yeah.
That's not even something that's been probably talked about between the family. That's not something we ask. We have no way of.
I didn't know, that's why I'm
Yeah.
asking.
It'll
So,
be up to them to make the arrangements of what they want to do. Like she just told you this quick, just being told last night, I'll pretty much be willing to wager that they have not even considered what they're gonna do.
My body can't even be released, so.
I've been there with parents, grandparents, and uncles. So I don't know if I have the right to or not, but like I was gonna call his former employees whom he really cared for and let them know.
You can call whoever you want.
I just don't want to do something that I'm not supposed to. How do I go about getting his wedding ring, engagement ring?
So one of the things that's interesting as part of like strategy, they probably felt like they didn't need to at this point, but imagine if the cops would have let her walk out of here. All the people she would have called, all the statements she would have made, all the witnesses to the probably different stories she would have told. And then they arrest her just like a week later, or a couple days later, or after the funeral. I mean, just imagine what she would have said to all these people.
It's at the medical examiner's office. It'll come to us eventually, and then
It'll be released to
oh,
the next
family.
of kin.
Yeah. Okay.
I bought it for him.
That is a civil issue.
And she wants the wedding ring or the engagement ring or whatever that he's wearing. Why do you think she wants that? Does this sound like it was just about picking up her cell phone?
It was on his finger, it goes to them, they're the ones that are gonna release it, we don't have any say in that.
So
And it was actually a great point by the judge. When she asked for her cell phone, it was clear she had not gotten an answer to that yet. It's not like she expected to get it back right then. She wasn't like, you told me on the phone last night, detective, that I was getting my cell phone today. She even got her days mixed up, whether it's Tuesday or Monday or if it happened on Sunday.
won't get that back. So for all of this, like, how do I find out what's what, how many, like, what's been found?
What do you mean?
Pillow with stain, swab of stain from pillow, suitcase.
That will all be sent off to
FDLE?
FDLE, Florida Department of Law Enforcement. They do their testing.
So, and then like whatever white can with blood and necktie with blood was from the suitcase.
Correct.
Why would you guys, oh, you'll see it in there, the baseball bat for Lucas and the speeds. And this is just his phone, my phone, and the laptop.
Yeah, when anything can be released, we will release it, but we are very early in this investigation, and it's not an overnight process, unfortunately.
So what's next?
They're gonna come and swab your fingers.
No, I'm talking about like in the long run. Like, what do I need to like, do I need to be doing something or like?
I can't tell you like, what to do. And
I mean, like, so like for, like, I don't understand, like, I don't know if you guys are just gonna like, because it makes it sound like to me, like, I'm being accused of something that was not intentional. I'm being accused of it. And a handful of other things that I'm being accused of.
Okay.
So I don't want to be at home with Lucas and you guys show up.
I understand that.
So,
We're still investigating. I don't know what you want me to tell you.
so is there going to be concrete whatever it is, and then it's like, okay, this is what it is kind of thing, or like, because I've done the whole court thing, I've done the whole attorney thing, I've done whatever. So if
I've done the whole court thing. I've done the whole attorney thing. So again, this isn't somebody who's being tricked, who doesn't know what's going on, who doesn't understand the process at all. All of that matters.
I'm not admitting anything about being intentional and I killed George.
Okay.
That's not the situation, but it's trying to depend on me.
So that's going to be another tough one with the battered spouse syndrome.
Okay,
That was not my intent. But it's trying to depend on me. So however, or whatever it is I need to do in order for that to be proven, then I need to do so, which is why I'm trying to get my ducks in a row.
okay.
So that's why I'm asking what the next step is other than me getting my nails swabbed.
I mean, you want me to tell you how to not be accused of a crime? Is that what you're asking? Like, I don't know what you
I'm
want.
trying to prepare myself for whatever may need to be done so I can, I guess, stick
wouldn't-
up for myself.
I mean, I think you're doing just fine.
I bet you do. The cop's like, I think you're doing just fine. Just fine for us, at least. Okay. So let's get back now to the judge's order. I'm going to answer a couple questions first. Buzzman said, Peter, what are your plans to go to the trial? I'm going to wait until they actually pick a jury because I don't know how long jury selection is going to go. Once they pick a jury, we'll have a better timeline as to what's happening in the trial, and I'll make a plan then, but I am going to get there for at least one day. Nico, from what you know of this judge, if or when she is sentenced, will Judge K give her a talking to like some judges do? Thank you so much. I expect him to be professional, but I do not expect him to go easy on Sarah Boone. I'll put it like that. Christy Allison, it feels like we've seen all the evidence needed for this case. Is it possible even more will come out of trial that we haven't seen before? So there was always two major questions in this case to me. Number one was intent. And if they're talking about second degree, would they be able to prove the mens rea, the criminal intent for that? Or would it end up being some kind of manslaughter? Maybe even involuntary manslaughter, some kind of negligent killing. I thought they had a pretty decent shot at that. The videos on her phone would make it difficult, but as far as like what kind of arguments a defense attorney could have made, that kind of seemed like the most obvious angle. But now the big question number two is battered spouse syndrome. What do they have? What evidence do they have? What reports do they have? What mental health reports do they have? What actions in the past do they have? And I think there's a lot we don't know about that. Could Sarah use now that she suffered wet brain so she didn't completely understand, or is she just cooked? Is there anything she can do now? Yeah, that's not an argument that ever wins. That's not an argument that ever wins to use it after the fact, especially when that's how you're acting and they watch it and you clearly are able to understand and have a conversation, hold a conversation, and go through this interview. All right, let's get back to the motion here. Whether the Miranda warnings were sufficient. The Fifth Amendment of the United States Constitution and Article 1, Section 9 of the Florida Constitution both provide for a right against self-incrimination. The self-incrimination clause of Article 1, Section 9 Florida Constitution requires that prior to custodial interrogation in Florida, suspects must be told that they have the right to remain silent. Anything they say will be used against them in court. They have a right to a lawyer, and that they can't pay for a lawyer, one will be provided, appointed for them and paid for by the state. Those are the four things. Not, do you understand these rights and are you waiving these rights? I think that should be asked. I think that's best. I think that's best practices. I think that's best policies, best procedures. But it's not in the case law or the rules as a must. Both the Florida Supreme Court and United States Supreme Court stressed that there is not talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. That means no magic words. A court does not examine Miranda warning as if construing a will or defining the terms of an easement. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. The crucial test for determining whether police gave a proper warning is whether the words in the context used, considering the age, background, intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. And that's why, as we sit here, as a criminal defense attorney who's a big fan of justice, and I want every criminal defendant's rights to be protected, I absolutely believe Sarah Boone understood what she was doing. And then she's free to make her own decision. She's free to make her own decision. The Miranda warning provided by law enforcement to the defendant at the beginning of February 25th, 2020 interview is sufficient under both federal and Florida law. The Miranda warnings given to the defendant in the instant case is identical to the exemplary Miranda warnings identified in Owens Supra. If you remember back to the state's response, that's a case the state cited. As such, the Miranda warning given to the defendant in the instant case was sufficient. That to me was kind of the easy one. We knew that that was going to happen. The totality of the circumstances and the coercion, that's maybe the better argument. I don't know. Let's read a couple footnotes. The court notes that this statement is an accurate statement of the law. While Detective Stoop said, "This is something I have to do when giving the Miranda warnings," this is an accurate statement of the law, as law enforcement officers are required to administer Miranda warnings prior to custodial interrogations. So I didn't even read that one before, but so the judge agrees with us, and this is why it was important to actually to actually watch the interview. Because if you watch the interrogation, to me, it's clear that's what she was referencing when she said we have to. In 1966, the United States Supreme Court issued an opinion in Miranda and established 4 warnings that are required prior to questioning when a person has to be taken into custody or otherwise deprived of his freedom of action in any significant way. Specifically, a suspect must be warned prior to any questioning that 1, he has a right to remain silent. 2, anything he says can be used against him in court of law. 3, he has a right to an attorney. 4, if he can't afford an attorney, one will be appointed for him prior to any questions if he so desires. And he read the Florida case law first, and then that's Miranda. Nationwide, baby. All right. So let's see now. Were the defendant's statements on February 25th, 2020 coerced? To establish that a statement is involuntary, there must be a finding of coercive police conduct. Generally, by the way, you notice how many cases the court cites in his order? Generally, to determine whether a confession is involuntary and coerced, a court must examine the totality of the circumstances surrounding it. When the voluntariness of a confession is in dispute, it is the state's burden to prove voluntariness by a preponderance of the evidence. There were no misrepresentations of the law regarding any defense, no quid pro quo, no directly or specifically made promises, no overt act or threat of force against the defendant was proved or claimed, no fear of material or physical harm, no hope of material reward, no indication that the defendant was a newcomer of the law based on the 2 times Miranda was provided between February 24th, 2020 and February 25th, 2020. No indication that the defendant is mentally deficient, especially considering the verbiage she used. No threats, delusions, deceptions, or promises. And the defendant was offered water breaks. Okay, so let's look at this real quick and just so I can tell you how this is done. He gives you all these different circumstances, and you may be thinking, why did he mention all these? Well, first off, he mentioned all of them because when you go through all the old cases and all the precedent, for reasons that we find that something is coercive or forced, these cases give their own specific factual scenarios, which other courts have found to be coercive or forceful police behavior. And this is why when Owens had no case law in his motion, I'm like, man, if this exists and you cited a case, that would help. And the court is saying, look at all these cases I found. You didn't cite any of these. You didn't even argue any of these arguments that have worked in the past. You didn't say there was a quid pro quo. You didn't say there was a fear of physical harm. You didn't say that they gave her a hope of a material reward. You didn't even say any of that in your motion and didn't cite any of these cases. But in an abundance of caution, I'm going to go ahead and make a ruling. None of that existed here. It wasn't claimed and there's no evidence of it. And then as far as the newcomer of the law, that's why I played that little portion. She's like, I've done the whole court thing and the whole lawyer thing before. And she was read Miranda 24 hours earlier. So this isn't all brand new to her. Now, even if it was brand new, even if it was the first time with Miranda, even if she said she didn't have conversations with lawyers or had been in court before, I still think this Miranda was appropriate and wasn't coercive. But that is something that can be an argument in your favor. Under the totality of the circumstances, the defendant's statements on February 25th, 2020 were not coerced. Whether the defendant's statements on February 25, 2020 were voluntarily made. A statement is not compelled within the meaning of state or federal law if an individual involuntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda v. Arizona. The state must prove by a preponderance of the evidence that a defendant's rights were waived. To constitute a voluntary waiver, the state must show, 1, that the waiver was the result of a free choice on the part of the defendant and not the product of intimidation, coercion, or deception. And the waiver made with a full awareness of the nature of the rights being abandoned and the consequences of the abandonment. I mean, do you think that happened in this case? Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Factors relevant to consider. Number 1, the manner in which the Miranda rights were administered, including any cajoling or trickery. The suspect's age, experience, background, and intelligence. The fact that the questioning took place in the station house. And the fact that the interrogators did not secure a written waiver of the Miranda rights at the outset. The Miranda rights were administered in a normal tone and cadence. There was no rushed or urgent speech. And again, video helps with that. There was no delay in administering of the defendant's Miranda rights. The recorded February 25th, 2020 interview reflects the defendant understood and acknowledged that she understood her rights. The defendant acknowledged that she understood her rights. The evidence supported the conclusion that the defendant voluntarily waived the right to remain silent and obtain counsel when the officer read the defendant his rights and asked the defendant whether he understood each of the rights, to which the defendant responded affirmatively. And then they continued to answer questions. The court reincorporates its findings above to further show no cajoling or trickery. The defendant was 42 years old at the time the statements were made and appears to be of normal intelligence. She might not be happy to read that. The February 25th interview did not take place at the OCSO office and it did take place there, and no written waiver was secured. So those are two knocks against the state. But under the totality of the circumstances, the defendant's statements on February 25th, 2020 were made with a voluntary, knowing, and intelligent waiver. And this waiver was a result of free choice on the part of the defendant and was not the product of intimidation, coercion, or deception, and that the waiver was made with full awareness of the nature of the right being abandoned. And again, the whole deception before or after Miranda, the court didn't comment on this. He says that he doesn't believe that phone conversation took place, so it's not really something that he has to look into. From my perspective, I hate it. I wish cops wouldn't do it, but I don't think that would be legally sufficient to suppress this entire interrogation. The amended motion, the second amended motion are hereby denied. Denied. So that interrogation is coming in as long as it's relevant and as long as it's going to bring points that the state can use appropriately. From my perspective, I would use it a lot. I would use it a lot in my case in chief as the state, so that when the defense puts on the battered spouse syndrome, the jury has already heard Sarah Boone's first incantation of what happened. D-Truck. What's the odds Owens is trying to negotiate a plea deal, involuntary manslaughter now that this motion is denied? Second degree M is looking more likely. I think he's always trying to work a deal, like he said. And with the pressure of the trial happening on Monday, it's possible, but I think we're full steam ahead here. But it also would not be surprising to see her plead to something like this, either voluntary or involuntary manslaughter, something less than second degree. Peter, did you ever clerk for a judge? Just curious. I did not, Fletcher boy. I did not. Being a judge, clerking for a judge, that never was like pulling towards me or something that I was interested in or ever gravitated towards. I don't know why. I think maybe I just like the action side of it more. That YouTube is awesome. It's a lot more action here than I ever would have expected discussing this stuff with you. Great questions and interaction. So I appreciate it so much. Pterodactyl. At first viewing, I felt the whole reason she went to the station was to find out what they knew and where their investigation was going to assess if they were looking at her or not. All manipulation. And who were they talking to? Are you going to tell this person? Are you going to tell that person? Should I tell them? Is it okay if I call them and tell them? And was she going to try to get her ducks in a row? As she said, what did she mean by that? I would have liked to have found out. Chris K said, Peter, here is reimbursement for your tax dollars that you paid Miss Cashman to watch your show. But seriously, if anyone can help with hurricane help, please do. Peter is matching up to $50,000. That is huge. DM him for the link. Yes, please check out our Instagram and Twitter. We're going to post an update about this today as to where we're at. We had a $100,000 goal, including the match. And I'll just tell you guys, so you can still check it out. We are at $48,000 in just 2 days. That's including the match. So 24,000 from you, 24,000 from me. And a lot of you are from the Carolinas, especially North Carolina. Like I said, we love North Carolina. This is Somebody Cares Tampa Bay. So it is a Tampa Bay-based charity that did awesome with hurricane relief for Ian. Well, guess what? Because of our donations, they let me know that they now have semi-trucks going to North Carolina. They've already gone to places in Florida. They've already gone to Georgia, where it was hit really hard. I believe Valdosta, Georgia. And now they're trying to push it as far as North Carolina to send supplies and help up there. So thank you to everybody that has participated in it. We're going to continue pushing. Sometimes it's easy if you're not involved in it to forget a week later, right? Like we've moved on to something else. The news cycle is so quick, but there are people still in the thick of it, still dealing with it, that'll be dealing with it forever. The government and insurance companies just will not step in and fix this the way that they should. And there are things in place that have been done to set us up to where when something like this happened, they should know that it was going to be like this, especially insurance companies. And there are laws in place to protect them and not the people. I don't need to get on my soapbox, but anything we can do to help, we should, and we are. And if you can't give, that's perfectly fine as well. We appreciate you guys being boots on the ground. Anybody that can do to help, praying for these people, calling these people, seeing what you can do to help them. Anybody that you may know there, maybe you can be a bright spot in their day, just talking to them and make them feel better. Jennifer C., just like the defense can't prosecutor claim, they also don't know what happened off camera, i.e. her using a bat to cause recent injuries. What do you think about Owens after this Hail Mary attempt to suppress? He didn't seem knowledgeable about Miranda and case law requirements. So I'm not going to make a final judgment on him. I think it was the right move to do this. I think it was totally fine to do this. I don't think the motion practice was the best, but I also don't know how much case law was there really supporting the argument he was trying to make. So okay so far, but I'll reserve ruling on that one, Caitlin. Broken Baker. Can Sarah Boone sue the judge for defamation? He only claimed she was normal intelligence. She's a straight A student. It's covered under immunity. Welcome, Michelle Rowe, Red Sky, and everybody else that joined the membership crew today. Lisa, thank you so much for helping us, North Carolina. Lisa, I wanted to, it was like on my heart as much as I could to possibly help North Carolina, but also it's hard for me because I don't know a lot of people in North Carolina or the charitable organizations in North Carolina. So when I did talk to them, I was like, if it's possible and we can do that. And they were like, yeah, we're already loading up the trucks and people to go help over here in Florida and over there in Georgia, but we'll see what we can do. And now their focus is on sending stuff to North Carolina as well. So I'm glad we were able to do that. So thank you so much to Lisa and everybody else for joining in on this. Make sure you guys hit the like button. Make sure you guys subscribe to our page if you haven't. Please hit that like button because we've got a lot of people watching these and a lot of people that want to watch these getting prepared for the trial. They all get to see my snafu of reading the wrong document for 5 straight minutes in this. They're probably like, what an idiot. How did you not notice? When I'm locked into the document, sometimes I don't see the chat and the text and everything else popping up on my screen. You guys are awesome. Sugar Frosted said, if this was likely to succeed, do you think her previous lawyers would have attempted this type of motion? This is in the discretion and decision-making of the lawyer. This is a strategy decision, falls right within one lawyer. I wouldn't blame a lawyer for not doing it. I wouldn't blame a lawyer for doing it. PJ322, hey, lawyer, big fan. FSU class 94 here. Go Noles. Oh, PJ, it hurts. It hurts, but yes, go Noles. Brock Glenn, new quarterback, starting against Clemson, kind of thrown into a tough spot. We just posted the relief fund in the chat as well. If you guys want to click that, go for it. I appreciate you guys. You are the best. We're going to continue following Sarah Boone and anything else you guys ask about. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.